Hello, and welcome to the course on English contract law. This session lays the key foundation for our journey, the common law. As lawyers trained in civil law systems, you're familiar with codes, statutes, and structured legal doctrines. In contrast, the common law takes a different path, one built more through judges than legislators. Let's explore what makes the common law system distinctive, why it matters for contract law, and how it compares to civil law traditions. What is common law? The term common law can be confusing because it's used in two ways. Narrow sense. It refers to rules developed by the old king's courts in England as far back as the Middle Ages. This body of law was common because it applied uniformly across the country. Wider sense. It means judge-made law, as opposed to statutes. In this broader use, common law includes decisions made by courts over time, primarily where no legislation exists. Today, when we say that English law is a common law system, we mean that many rules come from court decisions, not just acts of Parliament. And this is especially true for contract law, which remains largely shaped by precedent, that is, how courts ruled in earlier cases. Common law versus equity. Two histories, one system. Historically, there were two parallel court systems in England. Common law courts focused on rigid rules. Remedies were limited, often just monetary damages. Equity courts, led by the King's Chancellor, focused on fairness. These courts could give remedies like specific performance. That's when someone is ordered to do exactly what they promised. They could also grant injunctions, which order someone to stop doing something, and they could allow rectification, correcting a written contract so it reflects the real agreement. In 1875, both systems were merged into one court structure, the Supreme Court of Judicature. But even today, we still talk about common law remedies versus equitable remedies. Understanding this distinction is important in contract disputes, where courts might apply different remedies based on the nature of the claim. Civil law versus common law, key differences. As civil lawyers, you may be used to legal codes, structured systems where the law is built around broad principles. That's not how the common law works. Let's outline some key contrasts. Sources of law. In civil law, the law mainly comes from codes and statutes. In common law, it comes from judicial decisions and how those decisions are interpreted. Legal reasoning. In civil law, lawyers start from general principles found in legislation. In common law, they start from previous cases, what we call precedent, and argue by analogy. Role of judges. In civil systems, judges are often seen as applying the law. In common law, judges are also seen as creators of law, particularly in areas like contract law. Academic influence. In civil systems, academics play a strong role in shaping the law, often through legal doctrine. In common law, academic writings are less central, although modern courts consider them increasingly. The global reach of the common law. English common law has been exported worldwide, primarily through British colonization. Countries like Australia, India, Canada, and at least 16 African countries inherited the system. Even within the United States, most states follow the common law tradition, with a few civil law exceptions like Louisiana. However, each country has adapted the common law in its own way. There is no single common law of contract. For instance, the US emphasizes good faith and reliance, estoppel, more than English law. Australian contract law has also developed its unique principles. This diversity reflects the flexible nature of the common law tradition. English courts also tend to look across to other major common law jurisdictions with which they have strong links, particularly Australia, Canada, and New Zealand. In Jones versus Caney, Lord Collins of Mapesbury stated that it is highly desirable that at this appellate level, in cases where issues of legal policy are concerned, the court should be informed about the position in other common law countries. This court is often helped by being referred to authorities from other common law systems, including the United States. Why this matters for you. As future experts working in international or comparative contexts, understanding the common law mindset will help you. Read and apply case law effectively. Understand why a judge made a certain decision. Recognize how English contract law has evolved more compellingly through litigation, often later reflected in legislation, and spot differences in remedies available under common law versus civil law. To recap, English law is a common law system where courts develop much of the law. It evolved from two sources: common law courts and courts of equity. It contrasts with civil law systems that rely more heavily on codified statutes and doctrinal interpretation. Understanding these foundations is essential for working with or comparing contract law across jurisdictions. In our next session, we will look at Introduction to English Contract Law. Thank you, and welcome again to this exciting journey into English contract law.